Welcome back to the ECAG Navigator Journal Podcast, the voice of Australia's next generation of export control and strategic trade professionals. I'm your host, Jack Newbould. Today, we're diving into one of the most complex and consequential parts of Australia's compliance landscape, sanctions, how they work, who administers them, and what they mean for industry, government, and anyone engaged in cross-border trade. To guide us through this, I'm thrilled to be joined by Susan Danks, Director at Susan Danks Tariff Consulting, a leading sanctions and export controls specialist whose recent Navigator Journal article breaks down Australia's sanctions regime with clarity and precision. Susan brings decades of experience across the Department of Foreign Affairs and Trade's regulated environments, AML, CTF frameworks, financial institutional oversight, and the intersection between sanctions, export controls, and due diligence obligations. We explore the fundamentals of Australia's system, how the Australian Sanctions Office operates, and what businesses should be doing to stay compliant in an increasingly complex global environment. Let's begin. Susan, thanks so much for joining us today. I really appreciate you taking the time. We'll jump straight in. How did you first get into the field of export controls and sanctions?
Been involved for a long time. I am a licensed customs broker. And so, of course, export controls are an integral part of what we do. But also, I don't actually do any customs clearance if I run away screaming. I'm a customs broker I'm a consultant more than anything. So most of my clients are either customs brokers or importers, exporters. And so given that most of the work I do is consulting, it either tends to involve duty minimisation or compliance. And compliance is an issue that I've been pushing very hard many years now, actually since the dual use regulations came into effect, because people just don't realise and they do not look at the amount or the quantum of penalties being issued in Australia as against the penalties being issued for the same offence in, say, the Canada or the USA. We need Australian importers and exporters to be more aware and to basically make sure that they know what they're doing, purely because ultimately they're the responsible party. They cannot put it off onto a third party.
What role does DFAT and the Australian Sanctions Office play in administering sanctions?
So DFAT is obviously the Australian Department of Foreign Affairs and Trade, and the Australian Sanctions Office is a part of it. We tend to call it ASO, and it's Australia's sanctions regulator and is established within DFAT. The role of the Australian Sanctions Office is to provide guidance to regulated entities, so that it doesn't mean just businesses and individuals, but also government departments on sanctions legislation. And it processes permit applications for activities that would otherwise be prohibited under Australian law, and it promotes compliance with other agencies involved in sanctions export controls, such as the ABF, Australian Border Force, and you'll excuse me if sometime along I start calling them customs. They're currently called Australian Border Force, the Australian Federal Police, and the Department of Defence. And in doing that, it supports law enforcement and enforcement actions for suspected non-compliance. The ASO also publishes what's called the consolidated list, which is an Excel spreadsheet of sanctioned Australian entities and individuals. And it's something that if you are involved in export controls and sanctions, then you should, of course, also be receiving a copy and subscribing to the consolidated list. ASO or DFAT also communicates with the UN Security Council regarding UN sanctions and permits, and it can, if it needs to, issue notices requiring individuals or corporations to provide information to verify that they are in compliance with sanctions laws, because it's no good being administering it if you can't also then get the information that you need.
What exactly is the difference between UN sanctions and Australia's autonomous sanctions?
Okay, so the main difference is the origin of the sanctions. So United Nations, UN sanctions are multilateral. That means that they cover more than one country, and they're mandatory for all UN members as a result of a UN Security Council resolution. But in addition to adopting those sanctions, Australia has its own autonomous sanctions, which are imposed by the Australian government, federal government, as part of its own foreign policy. So autonomous sanctions can supplement UN sanctions, or they can address issues not covered by the UN. Generally, they cover two categories of activity, those associated with designated persons and entities, and we often call this, or you'll often hear this referred to as targeted financial sanctions. And then sanctions imposed against particular countries or regions or terrorist groups. And, we've all seen what's been going on lately with Gaza and Russia, and of course with some of the terrorist groups, Al-Qaeda, etc. Anyway, sanctions measures on designated persons or entities, as I've said, are called targeted financial sanctions, and they generally prohibit directly or indirectly, and that's an important qualifier, indirectly, making assets to or for the benefit of people or persons or entities designated in that sanction. And they can also prohibit using or dealing with certain assets controlled by them. So there was a notification went out, as an example, a while ago, and it was added to the sanctions list. There were about half a dozen boats owned by Russian oligarchs. And the way that would work under the sanctions is that if you're at a wharf and there's one of these boats that are mentioned, you need to call the federal police and tell them it's there. You cannot help, you cannot supply, you cannot do anything. There are broader, so effectively what it does is freeze these assets. There are broader restrictions on dealing with some assets under some frameworks. And of course, some individuals not only are subject to the financial sanctions, but also travel bans. And you would have seen newspaper articles in regard to them. The sanctions that apply to countries and regions and terrorist groups tend to restrict trade in certain goods or services or commercial activities within those countries or regions or terrorist groups. And generally they're a prohibition on the export or import of certain goods or services and just engaging in nominated commercial activities. There are, of course, additional measures that fall outside that sort of generic descriptor I've gave you, and that's matters such as handling stolen cultural property of Iraq and Syria. We all remember when that was going on, an enormous amount of cultural property was stolen and made available on the black market. And we have sanctions against that. If we find them, they're seized.
How do extraterritorial applications work for Australian individuals and companies?
Okay, so it's a very broad application. So Australian sanctions laws apply not only to activities in Australia by Australian individuals and companies, but also to activities by Australian citizens and Australian registered, the legislation I think says body corporates, but companies overseas. And it also includes activities on Australian flagged vessels or aircraft. Not that we've got many Australian flagged vessels, but so it's a very broad application. And what it means is that an Australian individual or a company can be penalised for violating our sanctions law wherever in the world they are and wherever that action took place. For example, I've had a client that Australian company, but they're manufacturing controlled goods offshore. They have had to obtain DEC approval and basically making sure that they are squeaky clean in terms of our sanctions and export controls. So I've already given you the example that I was going to give you of the Russian oligarch's boat. That's basically how it works.
Yeah, that's great and great insight. When might an exporter need both DFAT sanctions permit and a defence export controls permit?
Okay, so an exporter is going to need a DFAT sanctions permit and a DEC, a defence export controls permit, if they're exporting items on the defence and strategic goods list. Given that's a bit of a mouthful, we tend to say DSGL, Defence and Strategic Goods List. It's available on their website, and it's when they're supplying or exporting to a country or entity subject to Australian sanctions, and not just Australian sanctions. We can talk about that in a minute, but also US sanctions, especially if they're military-related arms or related material. So the DEC permit covers the control of the strategic goods, and the DFAT permit is needed to authorise activities that would otherwise contravene Australia's sanctions law. So what you do is first off apply for a DFAT permit, or that's the recommended action, before applying for the DEC permit, as the DFAT permit is a prerequisite for engaging in that sanctioned activity. And then once you've got that, you apply for the DEC permit through it's called MADE, My Australian Defence Exports portal, and it's on the Department of Defence Defence Export Controls website. Don't leave it until the last minute. It doesn't happen overnight.
That's good advice for some of our listeners, I'm sure. What types of actions typically lead to compliance issues or enforcement?
Generally, it's something to do with dual-use sanctions. So dual-use goods, for those who aren't fully aware, are goods that can be used commercially, but they can also have a military application. And the dual-use list is divided into two lots. I think it's roughly about 330 odd pages or something. So the first bit of it is the military list, and that's fairly obvious what they are: tanks, weapons of mass destruction. The rest of it are what we call dual use, and they're goods, as I've said, that have both a commercial and a military application. And it's quite surprising some of the goods that are on there. Vacuum pump, as an example, some O-rings, some computers. The difference is it doesn't cover all types of those goods. It only covers those types of good meeting the specifications provided in the dual-use sanctions. Now, we get our dual-use legislation from an international agreement called the Wassenaar Arrangement. And the Wassenaar Arrangement has been adopted by very many countries. So you would find that internationally the requirements are very similar, but not the same, because legislation isn't legislation until it's adopted into that country's acts and regulations. And so while we use the Wassenaar Arrangement, there are a few things, as I understand it, that we do not enforce. Yours is the same. There are some things that they're hyper about and some things that they're not. But what actions typically lead to compliance issues or enforcement is supplying or exporting controlled goods or technology, which is probably the most common. So this includes, and it's really important to note, not only the physical export of controlled goods, but also intangible transfers, like the electronic transfer of technology. So, or even things like, what falls within that is things like training. Training of overseas residents. Universities have a big issue if they're involved in this area in making sure that they do not inadvertently transfer technology that they're not allowed to. The other areas are importing, purchasing or transporting goods that originate from or have been exported from the sanctioned country or region. That transporting goods doesn't sound like much, but I think I said in the beginning, I'm a customs broker. Customs brokers and freight forwarders need to be right on top of this. Doesn't mean as you as the importer exporter are not responsible, but brokers and freight forwarders need to be, and shipping companies need to be right on top of this to make sure that they also do not inadvertently infringe. Another area is engaging in prohibited commercial activities with a sanctioned entity or country. What is a sanctioned commercial activity, though, can vary. And so you need to be really careful about what the regulation actually provides about what you're going to do. AUSTRAC gets involved quite often for providing services like financial or investment services or assistance, or universities, again, suppliers, technical advice or training that could assist with a sanctioned activity. And you know, within that, providing services to designated terrorist groups is also prohibited. And I think I've mentioned this, the intangible transfer of controlled technology. That can be something as simple as sending an email, taking a computer overseas with controlled technology included on it. Or it can also include all of the above, but through a broker, that is not a customs broker, but engaging a third party to act on your behalf, often involved with military goods and technology. And, you know, these issues can happen intentionally or unintentionally. Quite often, it's unintentional, and it's because the company isn't screening properly or isn't undertaking proper due diligence or just has outdated compliance databases. You must, these days, stay on top and up to date with your legal obligations. The penalties in Australia are severe. The penalties overseas are much higher.
So when we talk about obligations, there's an obvious one now in terms of anti-money laundering and counter-terrorism financing. How do they intersect with sanctions requirements?
Yeah, really, really good question. So they're often called AML, CPF, anti-money laundering, counter-terrorism financing. And they're a set of laws and regulations that are designed to prevent criminals from using our financial system to launder money or finance terrorist activities. They intersect with sanctions requirements because both aim to prevent illicit financial flows. But sanctions focus on specific countries and individuals and entities, and these AML provide focus on the broader risks of money laundering and terrorism financing. And we all see that now. You know, we hear about some of the methods that they do it, even, you know, for example, in copying counterfeit goods, and the money goes back to terrorism financing, etc. So sanctions screening is a key part of this compliance with these requirements. Because they need to ensure that they're not dealing with sanctioned individuals or entities, and that any suspicious transactions that could indicate a potential breach are identified and reported. And How do you identify it? How do you do it? What do you do with it? The big thing is sanctions screening of customers. Now, in Australia, we have the consolidated list, my apologies, from the Australian Sanctions Office. That needs to be a core component of customer due diligence to prevent transactions with sanctioned parties. One of the things, however, that I want to get in here is that remembering that we can also be caught by US sanctions. The consolidated list is just one of very many sanctions lists out there. There are bodies that you can use to, it depends on where you are in the market and the risk profile of your organisation and your customers overseas. But you need to do some sort of screening. You will find if you are using a customs broker, freight forwarder, who is using the, I only know this system, so I'm not promoting it, but if they're using CargoWise, which is a multinational software program that we all use in 170 different countries. If they're using CargoWise, then they can actually do that screening for you. Because I think when they when they register the job, they can run it through about 300 different lists. Whatever. If you are involved in international trade, it's worth asking your freight forwarder customs broker whether they're screening, because screening is an integral part of what you must do. And then, so you're screening your customers, you're monitoring transactions to identify any potential suspicious activity. And you know, for these requirements, anti-money laundering, that is, you're looking for what could be money laundering or terrorism financing. But in sanctions, of course, it's to identify transactions that might be a breach. And if you find any, then you report it to AUSTRAC. I'll talk about it more later on, but you need to do a risk assessment and develop policies. You need to have a formal policy in place to manage these risks. And you need to ensure that your staff and you, with management buy-in, undertake proper due diligence in assessing any jobs that you have, especially those in high-risk jurisdictions identified by bodies like the Financial Action Task Force. This can involve collecting more information to identify customer activities and understanding their activities. If you find anything suspicious, you have to report it to AUSTRAC. And there are big penalties for failing to report and for getting it wrong, aside from reputational damage. Imagine if your organisation was found to be assisting a terrorist organisation. Does not look good in the profile.
Susan, why can United States dollar-denominated payments create additional jurisdictional considerations?
The majority of countries, their sanctions, their export controls apply only to that country. However, US dollar payments and indeed US sanctions have extraterritorial effect. That means if you fall within the areas that they control, then you are also subject to their sanctions. And one of the big areas that catches everyone is that we all make US dollar payments, and payments made through the US banking system therefore involve that business in contact with the US's sanctions laws, purely because of the global role of the US sanctions system. So, for example, the customs broker, freight forwarder, shipping company, we tend to pay ocean freight in US dollars. Immediately, that transaction is going to be caught up with US jurisdiction. So what it means, bottom line, is that Australian businesses and banks have to consider both Australian and the US regulations whenever a transaction involves US dollars, even if it doesn't involve the US, even if it originates and ends outside the US. You need to screen for US sanctions as well as our own, even when it's a non-US entity.
What does good due diligence look like in practice?
This is something that I talk about a lot. Good due diligence for export control and sanctions should require as a minimum that a company has an ongoing and updated sanctions compliance program. It needs management buy-in. It must be updated as required. The staff must be trained, and that must be ongoing. What you need to be able to do is demonstrate and ensure that your company has a culture of compliance rather than indifference. And the big reason for this is that if a violation occurs, a company I don't know whether you're familiar with the term strict liability, but it's a strict liability offence for a company. That means that it hasn't got to be proven in court. You did it, you're liable, the penalties are significant. And the only defence you have is good due diligence. And therefore, you do need a sanctions compliant program. So you need to ensure that you're gathering the information you need. You need to ensure that you're assessing risk and what you can do to mitigate that risk. And you need to ensure you document it. When you do research or when you look up details of a company, you document it. That can also save you doing that same research 100 times, by the way. So in practice, what it means is collecting detailed information about business partners, about transactions, and about potential end users. Many of you will have heard of the Know Your Customer requirements. You need to be able to identify potential red flags to a transaction, to an end user, and assess any risks these flags represent, and then be able to implement measures to mitigate them, as well, of course, as keeping a clear record of what you've done. So what that often means is that a simple supplier declaration is not enough. And it will depend. Remember, we talked about risk assessment and mitigation. If you've got a company in the UK, it's probably not a huge risk. But if you've got a company in adjoining one of the areas currently in dispute, then you could have. So you need probably more than a basic supplier declaration in many circumstances. And that means that you need to collect comprehensive data on the parties involved, including their business activities, end users, holding companies, and the ultimate destination of goods or technology. I gave advice to a company once that was vaguely concerned that they were being led astray by someone that was buying from them. And what was actually happening, we found when they went into it further, was that company A would order from them, and then they would collect the goods, and then, it was in the Middle East, and then they would drive it over the border to a sanctioned country. So you need to have a good understanding of end users, and you will find online, DFAT, I think it is, or ASO, I've got a really good developing a sanctions compliance policy brochure. It's only a few pages, but it's well worth a read. As I've said, a simple supplier declaration is not enough. So have robust know your customer procedures to make sure that where it could be a risk, you can verify the ultimate beneficial owners of these parties. That is critical to ensure that a transaction doesn't indirectly benefit a sanctioned party, and identify red flags. Red flags are something that as a customs broker we live or die by because we're always looking for them. But unusual transaction structures, involvement of high-risk individuals or countries, that's customers who are evasive about their use of their goods, companies that don't want to give you details, that are hesitant to provide details, or that want to give you an email contact that is a personal email, not a legitimate company one. If you're given an email, check it actually is correct. That it's not, it's an email address that's close to but not quite. What you can also do is just jump on Google and have a look at the address to make sure it's a real address. It's not someone's backyard. In terms of the financial laundering, if they want to pay you in cash, that's always a bit of a heads up. Particularly, I think, and this may not be current, you would need to check, but I think anything over 10K cash payment is reportable. So if they want to give you cash payments and it's under that, it may be something that you need to look at. Document everything. Maintain detailed records of all due diligence steps, including the information you've collected, any risks you've identified, any mitigation procedures you've implemented, and the rationale for your decisions. It's no good saying, we identified X and we did Y. You need to say why you did it. You may have done, that can be a pest to make all these notes, but you only need to do it once. But this is crucial if a problem arises later, as these records can demonstrate that your company is making good faith efforts to comply with Australia's legislation.
I guess what would be a good next question is, can you share sort of a generalised example where due diligence prevented a compliance issue?
Say a company manufactures sensitive electronic components and is planning to ship them to a new customer in a country not on a sanctions list. So everything looks fine. The sales team has come to you, and we all know sales guys just want the sale. They've said, this is a great new client. And they gather the information that is a requirement by your company and submit it for the internal review. The company should have a compliance team which should do measures such as using software to screen the client against all relevant sanctions lists and denied parties lists. Now, even if you just do it on the consolidated list, it's something. It's a start. As I've said, customers are great border. If you ask, can probably do that for you. Checking the company's beneficial ownership to ensure no individuals on sanctions lists are hidden behind a corporate structure. And I don't know why, but I subscribe to a lot of US publications and Canadian and all sorts of things on penalties that have been issued. And it's surprising how often that happens, that you go back a couple of sales and someone that is a sanctions party is going to receive the goods. I can give you a US example. A poor jeweler, and I feel sorry for this man, a jeweler from the US got an order from Singapore for jewellery. Sounds fine, doesn't it? Singapore's fine. He's in the US, he's a jeweler. Why would he even think about it? So he sent the jewellery off. But what happened was that it was, I think, a sanctioned Russian person was just basically using that as a mailing address. And the ultimate recipient of this jewellery, valuable jewellery, was this person. And the jeweller, when it was discovered, received a very hefty fine from the US government. So you do need to be very careful in beneficial ownership. Then if there is any potential at all, and it's always dual use. You're going to pick up military straight away, I would hope. But investigating the stated end use of the components to make sure they're not for a prohibited purpose, such as a military use by a sanctioned entity. So become familiar with what's on the dual use list. And then what I've suggested to brokers or for their clients is that they could, if it looks a bit dicey, it's very easy to copy and paste the specifications into an email and say, are your goods of this type? For example, O-rings. We all use O-rings all the time. Well, everyone else uses O-rings all the time. I generally forget to. But we all use O-rings all the time. And I think it's a particular bite-on one that is restricted. And the reason it is that variety of rubber can be used in high-temperature applications, such as you would find in a nuclear reaction. And so you need a permit. So there's been a guy in Western Australia that has tried to mail to give you some idea of penalties, this was a few years ago now, tried to mail, say, half a dozen O-rings overseas. The consignment was stopped and he got a penalty at the time of only about $16,000 or something. It wasn't huge in penalty terms. But that same scenario in Canada would have ended in a penalty of about 96,000 Canadian dollars. And that same scenario in the US would have been a six-figure penalty. You'll understand when we talk later about where I see things going, where I think penalties will increase. But you need to always check that the goods that you are supplying are not of a type of the dual-use goods. And you've only got to do it once. You've only got to say, you're exporting these O-rings, are they of this type? And then against that part number, make a note that you've checked it and they don't comply. And the other thing to do probably doesn't involve a lot of people other than forwarders and shipping companies, is verify that the shipping route does not involve passing through a sanctioned country. Because if the goods pass through a sanctioned country, there is always the opportunity, of course, for pillage, for goods to go missing. So other things, if you do due diligence and you find that the client's registered country is not on a sanctions list, but a key individual in the client's parent company is on a sanctions list, and the end use that they're advising appears to be not correct, then you would need to halt the export order. And potentially what you should be doing is refusing to do further business with them to avoid violating any sanctions and posing significant penalties. So basically due diligence is what it's all about. And due diligence cannot be, and the reason for it cannot be overestimated.
No, absolutely. It's great advice, especially for our SME partners as well with ECAG. You mentioned there, the Australian context, especially with AUKUS. What changes do you see coming in the Australian landscape over the next few years?
Well, as I've just mentioned, there's a significant disconnect in the penalty amounts issued, for example, between Australia, Canada, US. I haven't looked at the UK's penalties, but the amounts being issued are significant. When I'm talking to brokers about their infringement notice scheme, because brokers are responsible apparently for most of the world's ill, they have initially the customs brokers infringement notice scheme. This had a very small amount of penalties issued. And then someone in the then customs went to Canada and saw that Canada received $20 million per annum in penalties, and came back to Australia, and now Australia has a very significant infringement notice scheme, penalty notice scheme whereby they also collect millions of dollars. And penalties can be issued even where no duty has been short pay, where it's an error in the statistical code. So it's quite important. So I truly think that given the disconnect between the penalties being issued, we will see a review of that. I also see that there'll be an increasing focus on sanctions for human rights, such as modern slavery. Over the last couple of years, we've got that legislation in, and corruption and cybercrime. Microsoft calling once too often. We might get more reforms to our export control regime, particularly those relating to Oscars. And we might get more complex compliance burdens and stricter export control regulations, including new offences for deemed exports and secondary supply and the provision of services. Because I've been talking on this topic, or mainly on dual use, for years, trying to wake industry up as to its importance. And while, many of you, those of you in the aeronautical and defence industries have been well aware of it, a lot of people aren't. It is something that everyone needs to be aware of. Another example that I give all the time is drones. And without going into too much detail, there are some drones that are just, you'd buy for your kid for Christmas. But there are other drones that are military, most definitely military. And then there's other drones that may or may not be caught up, that it's just a normal drone, but you attach a grenade to it and set it off over the border. So if you are in any industry caught up with any dual-use goods, you do need to be aware of what the legislation requires. I can see ASO, the Australian Sanctions Office, having increased collaboration with AUSTRAC, and potentially then we might get a bit more publicly disclosed enforcement activity, because we don't get a lot. I think that our sanctions policies will continue to be shaped by our policy objectives, foreign policy objectives. So ongoing sanctions against Russia and maybe new measures in response to global events like Israel and Gaza, which is supposed to be hunky-dory, but who knows. Whatever, export businesses do need and will need a deeper understanding of the controlled items on the defence and strategic goods list in relation to their own activity. I can see that we'll have major reforms potentially to the Defence Trade Control Act. We had amendments last year, the end of last year, and new offences commenced earlier this year, but we may have more. The new offences include deemed exports, and I talked about them. That's basically supplying control technology to a non-exempt foreign person within Australia without a permit, or secondary supply, which is supplying control goods from one foreign country to another, or to a foreign person in another country, and provision of services. So, I talk about freight, but really it can include training related or repairs related to specified military goods or controlled technology without a permit.
That's great advice. And I guess you've mentioned it a bit there about how informed businesses need to be. What steps can organisations take to be informed, but also to increase internal awareness of sanctions obligations?
As I keep reinforcing, I hope the best thing that a business can do, other than the compliance program, is a proactive and continuous monitoring. That's the key. So subscribe to regulatory alerts and newsletters such as those from DFAT and ASO, the consolidated list. Subscribe to newsletters from regulatory bodies, such as ECAG. and government agencies and specialist law firms. Sometimes the law firm ones are very high level and vague, but they can alert you to something of which you were not aware. Monitor the official websites of government agencies and industry bodies to make sure that any information you're getting is accurate and up to date. Join industry association so you get their newsletters. Implement, importantly, internal monitoring teams or technology solutions. So keep saying you need to have a compliance program in place, and that compliance program must have management involvement, must have management buy-in, and must include ongoing training of your staff. Have, even if you've got the amount of staff to verify it, a team that just deals with these issues. Use technology, such as the software that can automatically track regulatory changes and streamline compliance processes. I helped to develop some years ago a program called Borderwise. It's got a lot of the Australian legislation in it, but I'm sure that there are other things out there, or that your own IT guys can set up something so that you know what the legislation is with which you need to comply, and you need to perhaps even just register with mailing lists so that you're advised if it's updated. Yeah, that's probably it. What steps can businesses take to increase internal awareness? You know, so you're starting to look at how you can stay informed, but it's no good just being informed if you don't then increase awareness within the organisation of what the obligations are.
That brings us to the end of today's episode. A huge thank you to Susan Danks for sharing her expertise and for breaking down the sanctions framework that many organisations still underestimate. Even as the penalties increase and due diligence expectations tighten across DFAT, AUSTRAC and Defence. If you'd like to read Susan's full article, Australia's Sanctions Regime, you can find it in the latest edition of the ECAG Navigator Journal on the ECAG website. It's an essential resource for anyone working in export controls, supply chain security, financial compliance, or international trade. As always, ECAG's mission is to uplift capability, strengthen Australia's sovereign compliance ecosystem, and support the professionals who keep our system trusted and resilient. I'm Jack Newbould. Thanks for listening, and we'll see you in the next edition of the Navigator Journal Podcast.